The first letter arrived on August 3rd, 2025. It was from the woman whose wrist had been crushed in the crowd at the east exit, and one sentence in it stayed with me. Last week I watched him check a panic bar 3 times before children were allowed into the room. I read that sentence twice. It held the truth of the whole case. That is the case I want to tell you about. I want to tell you how we got there, not to make a hero out of a man who made a serious mistake, and not to ask you to forget what that mistake cost. I want to tell you because there are times when a courtroom does not bend away from harm and does not bend away from the person who caused it either. It holds both. This was one of those times. I want you to subscribe before I keep going. Not because what I'm about to tell you is dramatic, because it is the opposite of dramatic, and those are the stories that need the most people to hear them. Subscribe and turn on notifications, then let me continue. The file first came to me as People vs. Daniel Rojas, filed on March 22, 2024 in Cook County. The charges were reckless endangerment, obstruction of emergency egress, and criminal violation of Assembly Safety Code. On paper, it was clean and cold. A nightclub manager had locked 2 side exits during a fire evacuation. 14 people were injured. 1 woman needed surgery on her left wrist. That was the paper version. It was true. It was not complete. Daniel Rojas was 34 when he walked into my courtroom. The first thing I noticed was the frayed edge on his left shirt cuff, as if the shirt had been washed too many times and ironed anyway. The second thing I noticed was what he did with the yellow legal pad in front of him. He squared it with the edge of the defense table every few minutes, not from vanity, but because his hands needed a job. When the clerk called the case, he stood before his lawyer did. That told me something simple. He knew where the weight belonged. Maya Ellison was 31. She came in with a light brace still under the sleeve of her jacket, and before she sat down in the front row, she looked at both side doors, then the main door, then sat where she could see all 3. Most people would not have noticed that. From the bench, I did. Later, when she spoke, what she wanted was not what the case had assumed she would want. She did not ask me to ruin him. She asked me to make him useful. There is a difference, and she was clear enough to know it. What happened took place at 1:16 a.m. on Saturday, March 16, 2024, at Meridian Room, 214 South Halsted Street in Chicago. There were 186 people inside a room licensed for 160. A dimmer pack behind the stage curtains overheated. Smoke started first. Then a short burst of flame ran up the back drape. The fire itself was contained within minutes by sprinklers and staff extinguishers. The injuries came from the crowd and the delay. Daniel was managing the room that night. When the alarm began, music was still running through the house system for 6 more seconds before the sound cut. Security opened the front doors. The north side exit had a deadbolt thrown earlier in the night after a street fight outside. The alley exit had a bar gate on a magnetic lock. Daniel gave the order that turned the whole case. He said, "Front only. Keep the alley shut." He said later that he believed the front entrance was wider and cleaner and would stop people from piling into a narrow service lane. He was wrong. The wrongness of it matters. I am not going to trim it down for comfort. When people hear a fire alarm in a crowded room, what saves them is not calm talk or good intention. What saves them is open space and open doors. By directing everyone toward one front exit and leaving 2 side routes closed, Daniel turned fear into a bottleneck. Maya Ellison went down near the east wall when the crowd shifted. Her wrist broke under another person's heel. 2 people suffered smoke inhalation serious enough to stay overnight. A busser named Luis Herrera cut his shoulder on a metal kick plate trying to force a side door that should never have been shut. I am still thinking about what this case taught me. Subscribe, because before this video ends I am going to try to say it out loud, and I want you to be here when I do. Subscribe now. Before anyone testified, I had to decide what kind of sentencing record I wanted. The law gave me a range. Daniel faced up to 3 years in state custody or probation with strict conditions if I found that community safety would be better served by a sentence built in the open instead of behind a wall. What helped me in this case was a tool most people never hear about, a supplemental presentence report. In plain language, that meant I was allowed to ask for more than an arrest packet. I could ask for work history, mental health history, training records, victim statements, supervision plans, and anything else that would help me see whether a sentence could be designed to do real work. Discretion is a word people hear and often distrust. I understand that. In this courtroom, discretion meant I was not forced to pretend every reckless act grows out of the same kind of person or requires the same kind of response. It meant I could consider the harm, the risk, the record, the honesty of the defendant, and the needs of the people hurt. It meant I could ask a harder question than how much punishment fits. I could ask, what structure will protect the public best now? That is a different question. Sometimes it points in the same direction. This time it did not. From the bench, entrances tell me things. Daniel came in first on the first day of evidence, not because he wanted to, but because defense counsel had told him where to stand, and he followed it closely. He did not look at the gallery. He looked at the exits. He did it more than once. I noticed the count of it. People who have been near a bad room often do that without planning to. When he sat, he kept his hands flat on the table until the first witness was sworn. Maya came in a few minutes later with her older brother. She walked more slowly than Daniel had, and when she got to the first row, she moved her bag off the seat next to her so another injured patron could sit down. She did not look at Daniel first. She looked at the court reporter, then at me, then at the witness stand. It was the look of someone deciding where the truth would have to pass through before it reached the record. From the bench, I could see that she had already done some hard thinking before she entered the room. Turn one came from a firefighter I had not expected to matter beyond the timeline. Lieutenant Aaron Price had been first through the front entrance with Engine 46. He testified about smoke, alarms, crowd movement, and the delay at the side exits. Then the prosecutor asked him one short question about Daniel's conduct after the room started clearing. Price said, he kept saying, "Count Luis again, Count Luis again." That was the sentence that changed the file into a person for me, not because it excused anything, because it did not. I sat there and thought about what that sentence meant. In the first minutes after he had made the worst choice of the night, Daniel was not asking who had seen him or how bad it looked, or whether the cash drawer had been secured. He was asking about the dishwasher who had trouble with English and usually took instructions from the cooks. Lieutenant Price said Daniel asked 3 times, then tried to go back in and had to be stopped because the smoke layer had dropped too low. That did not erase the order he gave. It told me the order had come from panic and bad judgment, not from indifference. What I did with that mattered. I did not become soft on the facts. I became more careful with them. I ordered the probation office to dig further into Daniel's work history, the ownership structure at Meridian Room, prior safety training, and what he had done in the months after the fire. Once a case turns into a person, a judge has a duty not to look away from that fact, not because kindness is easy, because accuracy requires it. The incident itself stayed plain all the way through trial. At 1:14 a.m., staff smelled electrical burning behind the curtain line. At 1:15, Daniel radioed for the house lights. At 1:16, the alarm sounded. At 1:17, security opened the front doors and moved people toward Halstead Street. At 1:17 and a few seconds, Daniel said, "Front only. Keep the alley shut." At 1:18, people were pressing against the east wall where Maya fell. At 1:20, Engine 46 arrived. By 1:23, the fire was contained. The room had been survivable. The exit pattern made it dangerous. There was a complication the defense wanted me to make too much of, and I would not. Ownership had pressured Daniel for months about theft, unpaid re-entry, and crowd control. Text messages showed that the owner had said, "No side door traffic after midnight. Ever." But adult men do not get to hand their judgment over to a text message and call it obedience. Daniel gave the order. Daniel carried responsibility for that order. The owner's pressure belonged in the picture. It did not replace him inside it. Subscribe if you believe that courts are not only places where people are punished, they are also, sometimes, not always, but sometimes, places where people are met with something more than they expected. Subscribe for those moments. This is one of them. Turn 2 arrived in a red binder with a split plastic edge. It was handed up during the sentencing phase after guilt had already been established on the plea. Inside were 62 pages. There were Daniel's certificates from a 40-hour crowd management course he started on his own while out on bond. There were sign-in sheets from 12 Saturday sessions at the Chicago Fire Prevention Bureau. There were handwritten notes in English and Spanish about panic bars, occupancy counts, and alarm release systems. And there were emails sent before the fire asking ownership to repair one failing latch and remove decorative chains from a service corridor after closing. Facts carry weight in a courtroom when they point in one direction more than once. That binder did. It told me Daniel had not spent the months after the fire arranging excuses. He had spent them learning the exact kind of boring, repeated technical material that only matters deeply to people who understand what went wrong. The law did not require me to care about that. Discretion allowed me to. More than that, it allowed me to act on it. I remember one reaction in the room when the binder was marked as an exhibit. Maya did not smile. She did not nod toward Daniel. She just put her right hand flat on the wooden rail in front of her and left it there while the pages were described. It was a small movement. From the bench, it looked like someone steadying herself while deciding whether the future being offered in that room was real enough to trust. The defense, for once, was arguing for something I was already beginning to consider. Daniel's lawyer did not come in asking me to call the case minor. I respected that. He said the injuries were real, the risk had been high, and a jail sentence would be lawful. Then he said something more honest than I usually hear at that table. He said, "Uli, if this court thinks my client should not manage a crowded room again until he earns that right, I agree." That was advocacy, yes. It was also truth. Where the defense was wrong was in how often it tried to make Daniel sound like a man swept along by bad systems and stronger personalities. Systems matter, owners matter, training matters. But the law asks me to sentence a person, not a fog. Daniel was not a bystander to his own choice. He was the manager on duty. He spoke the order. He watched other people carry it out. I kept that in front of me all the way to the end. When Daniel testified, I listened less for polish than for where he stopped protecting himself. Early on, he said, at 116, I thought one open path was safer than 3 confused ones. That told me something true about his circumstances. He was trying to manage a crowd with the wrong idea in his head. Later, he said, I locked a door when people needed every door. That told me something else. The accountability was not being dragged out of him. It was there already. Then his lawyer asked him what he had been doing with the safety classes and venue visits while awaiting sentencing. Daniel looked at the table, then at me, then back at the table. He said, if I ever earn the right to work in a crowded room again, I want the first thing people know about me to be that I check the exits before I count the money. That was the moment I knew what I was going to do. I wrote it down, not because I needed to remember it, because I wanted to. Subscribe. Because if this case surprised me, and it did more than once, I think what comes next will do the same for you. Subscribe and stay with it. That line of his pulled a memory into the courtroom that had not been there a minute earlier. I was 11 years old in a church basement on the south side, wearing a paper tie for a school music recital. The room smelled like floor wax and old coffee. My father came in late from work, still in his gray jacket, and before he sat down, he walked to each exit and pushed on the panic bars with 2 fingers. He did not explain himself. He just checked the doors, sat in the back, and folded the program into a square. I had not thought about that in years. Then Daniel said what he said, and there it was again. By the time we reached sentencing, I had made the decision carefully. The room knew that. People can feel it when a judge has come in still choosing, and they can feel it when the choosing is over and the explaining is about to begin. Daniel was standing with both hands on the table. Maya was sitting upright, not leaning back, not leaning forward. Her brother had both elbows on his knees. In the second row, one of the firefighters had come back in uniform on his day off. Nobody was restless. I had made this decision carefully. I had made it knowing that mercy, to mean anything, has to be precise. Vague mercy is just hope. Precise mercy is a plan. I had a plan. Subscribe. What I said from that bench was the hardest good thing I had done in a long time. Subscribe and hear it. I began with the financial part because harm has costs, and those costs do not become less real because the person who caused them feels regret. I said, I'm ordering you to pay restitution in the amount of $86,400. That amount will go first to Maya Ellison, then to the 13 other injured patrons for uncovered medical bills, physical therapy, and lost wages documented in this record. Money does not restore a crushed wrist or remove smoke from memory, but leaving those costs on innocent people would repeat the harm, and this court is not going to do that. Then I added a fine. I said, I am also ordering a fine of $12,500 to be paid into the Chicago Fire Prevention Public Education Fund. I am doing that because this case was not only about one room on one night, it exposed a weakness that exists in many rooms. Some part of this sentence needs to move outward beyond the names in this file and make the next room safer than the last one. I meant every word of that. The restorative part was the center of the sentence. I said, I am ordering 600 hours of supervised restorative service with the Chicago Fire Prevention Bureau and the city's Assembly Safety Program. That will include exit audits, alarm release testing, and monthly public safety trainings for venue owners, staff, and youth event organizers. You caused harm through a closed path. The right response is not only that you lose time, it is that your time becomes useful in the exact place where your failure lived. The structured part had to fit the man the evidence showed me. I said, you may not work as a venue manager, floor supervisor, or crowd control lead during the first 12 months of probation. During that same period, you will complete the National Fire Protection Association Crowd Manager Certification, 24 hours of counseling focused on panic, control, and decision-making under stress, and one community college course in building safety systems. I am not ordering busy work. I am ordering the things this record tells me you need if you are ever going to be trusted near a crowded room again. Then came the relational part, which mattered more than people often think. I said, you will perform one Saturday each month of service with the Near West Youth Arts Center, not inside nightlife, but inside a space where families gather and children come through doors expecting adults to have done their job. Your duties will include room setup, exit walkthroughs, and written safety checklists under staff supervision. I want you tied to a community that will feel the quality of your attention in real time. Accountability grows when other people can see it. I added one more part, and it was my way of speaking as clearly as I could without stepping outside the bench. I said, there is a condition for early completion. If after 18 months you are current on restitution, have completed every training requirement, and have documented 300 successful venue exit inspections with no violations of your own, I will consider a motion to reduce the remaining term by 6 months. I am putting that in the sentence because a court should recognize sustained work when it sees it. That was as close as I could come in that setting to saying what I believed, and I did believe something plain. I believed Daniel could do the work I was ordering him to do. Then I spoke to him directly. I said, Mr. Rojas, on March 16th you took away time and choice from people whose only job that night was to get out alive. Maya Ellison still lives with pain in her left wrist. Luis Herrera still has a scar on his shoulder from a door that should have opened. Other people in this record smell electrical smoke now and turn toward exits before they can think. That belongs to what you did. I let that sit in the room. Then I said, your charges do not contain every fact about you. They do not say that when the room was failing, you kept asking whether Luis had made it out. They do not say you spent months studying the mechanics of exits that you once misused. They do not say whether you are capable of becoming safer for other people than you were on that night. I have had to decide that from the evidence, and I have. Then I gave him the one sentence I wanted him to carry. I said, Daniel, spend the rest of this sentence becoming a man who opens doors faster than he ever closed them. Thank you for staying with this story. It is not the kind of story people usually tell about courtrooms. Subscribe if it is the kind of story you want more of. I have more to tell. What happened next was small, which is often how the true part of a day shows itself. As the courtroom began to empty, Maya stepped out from the first row and walked to the defense table. She set a folded card beside Daniel's legal pad and said, "Read it later." He looked at it but did not touch it until she had turned away. I saw that from the bench, and I remember being glad he knew enough to wait. Before I stood up, I signed the last page of the sentencing order, and then, without meaning to at first, I looked at the two side doors in my courtroom. Both were open. On that day, that ordinary sight felt different. The specific thing that happened later is the one I opened with. On August 3, 2025, Maya wrote to Chambers through the clerk's office after getting permission to submit a post-sentence note for the file. She had attended a children's dance recital at the Near West Youth Arts Center. Daniel was there in a gray work shirt and had been assigned to the safety walkthrough before families were seated. She wrote, "Last week I watched him check a panic bar 3 times before children were allowed into the room. That is all she said about him. It was enough. No appeal was filed. I will tell you honestly what that meant to me. I was relieved. Not because I doubted the sentence could stand, because I wanted the work to start at once, and appeals can turn a living sentence into paper waiting on a shelf. The part about the law came later, and it came because the record in this case was detailed enough to travel. In my written order, I made findings about alarm-linked door release systems, side exit access, and the danger of owner-imposed after-midnight locking practices in assembly spaces. The city's Public Safety Committee requested the transcript. 4 months later, Chicago passed the Meridian Egress Ordinance, which requires any door serving an occupied assembly room to fail safe and release automatically the moment a fire alarm activates. The next year, the state fire marshal adopted the same release rule into the statewide assembly code. Annual inspections now include an alarm release test. The law did not change because I gave a speech. It changed because the record was clear enough that people could no longer pretend not to see the gap. Here is what I came to believe because of this case. Mercy that asks nothing is not mercy I trust. It asks too little of the person who did the harm, and too little of the court that claims to care about what happens next. It would have been easier for me to choose one clean idea and live inside it, send him away and call that firmness, or cut him loose and call that grace. Both would have spared me the harder labor of design. Precise mercy costs more. It costs time. It costs attention. It costs the willingness to be misunderstood by people who think punishment is the only form seriousness can take. What this case showed me again is that accountability and belief can stand next to each other without weakening either one. I have seen that before, though not often. I hope to see it again. And the thing this case gave back to me as a person was a small trust in careful honesty. If you have been where Daniel was, not in his exact shoes, but in that hard place where you know you caused real harm and you do not know whether there is a path forward, I want to tell you one thing I look for from the bench. I look for the moment when a person stops arranging the facts in a shape that favors them. I do not mean tears. I do not mean a good speech. I mean plain contact with the truth. If you want a court to see you as more than your worst hour, start there. Say the hard sentence first and stand still inside it. If you have been where Maya was, hurt by someone, then asked by a system whether punishment alone is what you want, I am not here to tell you what to want. That choice belongs to you. I can only tell you what I have watched from the bench over time. When mercy is chosen freely by a victim, not pulled out of them, it often seems to return something control had taken away. Not all at once, not every time, but I have seen people sit straighter in their own lives after making that choice for themselves. I still have that letter in the file copy I kept for my notes. It says, "Last week I watched him check a panic bar 3 times before children were allowed into the room. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if you leave a comment, leave it the way people speak in the back benches of a careful courtroom when they understand that justice and humanity are not enemies."